Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. And now, without any further ado, it's my honor to present our afternoon speakers, Judge McBride and Judge Woolard. Judge James McBride served on the bench for over 20 years and brings extensive experience to his ADR practice. During the last 10 years of his judicial career, he was a member of the court's Civil Trials Division, 2 years of which were spent as the presiding judge. Judge McBride draws upon a lifetime of diverse experience and expertise. Born and raised in San Francisco during a time of great ethnic, economic, and cultural transformation, attending UC Berkeley as students led the change in the nation's perspective of society and politics, and serving the community as a police officer for the San Francisco Police Department. He's known for his intelligence and ability to master complex issues and is equally well regarded for his talent in facilitating settlement in even the most difficult cases. Judge McBride has been honored on 2 occasions for his service to the court, once as the Bar Association of San Francisco Barrister's Choice Award in 2003, and once as the San Francisco Trial Lawyer Association Judge of the Year in 2001. Today, we also have Judge Charlotte Woolard joining us. Judge Woolard of San Francisco Superior Court joined ADR Services Inc.'s panel after 22 years on the bench. Judge Woolard served for nearly a decade as judge in the civil court, in the law and motion, trial courts, and appellate divisions, where she held several positions in court leadership as the supervising judge of the Unified Family Court and presiding judge of the appellate division. Prior to her appointment to the bench, Judge Woolard was a civil litigator at a major national law firm. As a neutral, she has leveraged her diverse judicial and civil litigation backgrounds to effectively and expeditiously resolve disputes as a mediator, arbitrator, and temporary judge. Her practice focuses on family law, complex business and commercial disputes, employment, and real estate. Now, without any further ado, I will hand it over to the 2 of you for our presentation.
Okay. Well, thank you, Ms. Jones, for that wonderful introduction. We don't have time for me to correct any details, so I will just accept it at face value. We have a lot to cover today, so I want to jump right into it. We want to start out with the big picture, then go through the goals of the rules. And by the way, they're new rules. I think you by now you know that from our previous presentation. Then we're going to grade a few new rules. I was terrified when I found out later than I should have there were new rules. But we're going to go through in detail and examine a few and show you you shouldn't be afraid. And then finally, we're going to look at some of the recent opinions on what I consider to be some real hot topics coming up. So the State Bar is actually part of the Supreme Court. It's a public corporation that's involved, that's actually embedded in the Constitution. The goals are to regulate the professional conduct of attorneys and establish standards for discipline. The Supreme Court, as you may not know, is the final arbiter of all formal attorney discipline. And there's 2 ways that you can run into trouble. You can violate any of the rules, or you can violate the State Bar Act. Take a look at Business and Professions Code 6000, that's that. Judge Woolard.
Okay, so the Supreme Court says the purpose of discipline is not to punish the lawyers. And they've stated it quite clearly in Ray Kramer, a 1975 case. The purpose of the disciplinary system is to not be punitive, but to inquire into the fitness of the attorney to continue in that capacity to the end that the public, the courts, and the legal profession itself will be protected. Next slide.
So I'm sure that's all a comfort to you. By the way, I checked into Mr. Kramer. Things did not go well for him. You know, I think he turned out ultimately not to be fit after the Supreme Court gave him a hand up. So a complaint's initiated by anyone in the world, including, you know, opposing counsel, your client. The bar can take a look if they think so. After there's a complaint, they're all investigated. I don't think they dismiss any out of hand. If you receive a notice you're being investigated, cooperation is mandatory. You cannot stonewall it, and stonewalling an investigation is a separate basis for discipline. Finally, if you're going to be charged, you can actually get into negotiations about a settlement, but once that fails, if it does, they're going to file charges. Next.
And then we have the trial and possible appeal. The state bar court trial, the burden of proof is clear and convincing evidence. There is no code of civil procedure. You go by the rules of the state bar court. The court makes a discipline recommendation. If the charges are proved, then the court recommends the discipline to the Supreme Court. You do have a right to appeal. If you do appeal, it's taken to the review department, which is a 3-judge panel. Then they also would make a recommendation to the Supreme Court. And the Supreme Court recommendations of suspension or disbarment are reviewed. Typically, most cases are summarily affirmed. We have situations such as Kramer, who was convicted of possession of marijuana for sale, a felony, served 18 months in state prison, but had no other disciplinary or criminal conviction, and was not at the time serving as a lawyer. He was not practicing law at the time. There, the state bar court implemented a 5-year suspension. The Supreme Court in that case said, no, we think a 3-year probation would be sufficient. Then we have the Supreme Court going the other way in the Bradshaw decision from January of 2020, in which the review court recommended not suspending Mr. Bradshaw for allegedly pilfering $157,000 from his 90-year-old client's trust fund. And the Supreme Court unanimously said, no, we think you should reconsider and look at disbarment. So they returned it to the court. Next slide.
Okay, so just to calm those down who thought everything was fine after the last presentation on substance abuse, let's take a look at the big picture of discipline. The bar has a tough job. They took in in 2020, 17,488 new complaints. There's 200,000 active members of this bar. That's less than 1% of us got complaints. And the bar only filed charges against 180. All right. So of those 180 charges filed, there were another 63 that settled by some kind of negotiated disposition that does not become public. Disbarment. These numbers aren't going to match up because the results in a given year are not necessarily the same as a filed year. But if you do get charged, look at the way it goes. 97 disbarments of the cases pending, and 83 probation with actual suspension, and 31 with state suspension. So the overwhelming outcome is, if you go that far, if one goes that far, is you're in deep trouble. The good news is, if you look at the top, a lot of clients, a lot of cases are just not sustained. On a rather personal note with respect to this, when you get a notice of investigation, if you do not panic. I had a client who was also a friend, who probably had some mental health issues back in the day, who attempted suicide rather than deal with it. when he finally straightened out, we beat the bar charge to 0. In fact, they probably should have given him a commendation for the fine work he did. So make sure that you deal with this in a calm manner and try and keep these, I think, encouraging statistics in mind. Next.
So for many years, the state bar has been under pressure to do a better job on discipline. And we have here 3 times in which the state auditors report on the bar, 2009, 2015, and 2021. But the state bar has been known to not consistently prosecute the attorneys who have been found to be possibly violating their disciplinary obligations. We have, in one case, a particular Southern California lawyer, Tom Girardi, who was a fabulously wealthy lawyer and flaunted his wealth and was very well known, but for years apparently had been bilking clients and co-counsel and others of millions of dollars. And he was reported repeatedly to the state bar. Nothing happened. And then finally, in a very large case of airline crash in Chicago, the Girardi was a plaintiff's lawyer, settled the case for an undisclosed amount, but obviously millions of dollars, and money to co-counsel and the clients was not forthcoming. Finally, a bar investigation was reported on him, and one took. Previously, he had been reported apparently numerous times, but he had friends in high places and he was never subject to any investigation. So he was found to have violated the rules, was disciplined and disbarred, but ultimately then he became disabled. He had developed Alzheimer's and also claimed impoverishment. Next slide.
So, Judge Woolard, that's an interesting story that foreshadows some of the interesting mental capacity cases we'll be getting into. So, I'm not usually in the business of feeling sorry for administrative agencies that try to run my life, the DMV, the IRS, the state bar. But every 6 years, they become a punching bag for the state auditor. And at the same time, all that's going on, they were under pressure to reform the rules of professional conduct. And, I thought, well, what was wrong with our rules? And I think the major problem was that we kind of didn't match up with all the other states that went along with the ABA model rules. So as our esteemed colleagues, Lambden and Chin, explained earlier, it took a long, long time to get these rules done. The first commission spent 10 years. The Supreme Court didn't want to do it piecemeal. They wanted the whole thing. Then apparently Lee Smalley Edmund took over, if you were listening the first time. And within 3 years, they submitted an entire new battery of reports of rules to the court. But they had to go back to the drawing board. Judge Woolard.
So back to the drawing board. The Supreme Court was troubled by the unwieldy, lengthy process to that point. They sent a letter to the bar, to CEO Dunn, and they ordered them to establish a commission by November 26, 2014, and to complete work on the proposed rules and submit it for final consideration by March 31st, 2017. They were ordered to begin with the current rules and then focus on revisions necessary to address the new developments and eliminate the unnecessary differences. And what they were striving for was to adopt the model rules that so many other states were adopting that we had not yet adopted, or adopt the model rules in some version that would adequately protect the California citizenry. Next slide.
So in the Supreme Court's kind words of advice to the new commission about how to handle this, they wanted to make sure that we matched up with the ABA rules to the extent possible. That accommodates multi-jurisdiction people. It makes it all the same numbering. But they emphasized they wanted clear, enforceable disciplinary standards, and they wanted rules that would facilitate enforcement. So we get back to the big picture of the bar getting routinely criticized for failure to process discipline complaints. And now we got the Supreme Court weighing in, said, write some rules that the lawyers can follow and are simple to enforce. Judge
So the
Woolard.
Supreme. Oh, go ahead.
No, go ahead. Oh, no, it's me. Sorry.
It's you.
So, as you know, the Supreme Court, something like 79 new rules. And I must say that sent a shiver down my spine when I heard it. I thought, oh my gosh, I'm only familiar with a few of the old rules. Now I got to go through the new rules. But they did a good job of meshing our old standards with new standards. But we've decided for purposes of this that we would take up 16 brand new rules that have no former counterpart. And that really gave me concern, because I'm wondering if, with all of the case law and rules that we did have in place, I wonder what could be new. So we've decided to try and lighten this topic up a little bit by grading the work that they did on the new rules. And then these two next slides are just a list of the brand new rules. And there are some, there's some really sensible ones. There are some that we've divided into the potential can of worms society. We've divided others up into absolutely brilliant, straightforward. And then we've done some others where we wonder why this even exists, except everybody else did it, so we need to do something. Judge Woolard, there's new terminology, right?
There is. And the first rule we're going to talk about is Rule 1.0.1, terminology, and we give that a grade A. It's very clear, it's very concise. One of the attributes of this particular rule is that it puts all of the definitions in one rule. You don't have to go searching through all of the rules trying to find the words and phrases and their definitions. The new rules are very specific, very they obviate the need to look to case law or ethical opinions to comprehend the ethical standard, and they are very clear and enforceable. They let the lawyers know exactly what it is that is could be in violation.
So in the new rules, we differed a little bit from what the ABA says. The ABA actually, if you do read the model rules, they're a little fuzzy. They sound nice. In fact, the Supreme Court in one of their letters was threw a kind of a not so subtle jab at the rules, saying we want clear enforceable rules. stay away from aspirational standards. You know, do good, avoid evil is not, it's a great principle. It's a bad rule of discipline. So for instance, the ABA uses denotes in a lot of its definitions. The Supreme Court didn't like that. And they said, you know, denotes, if you look it up, kind of means suggest, infers, could mean. We use means when something means something. I like that. Okay. 1.2. This rule, the new rule, defines the scope of representation and allocation of authority between client and lawyer. Now, I did a double take when I found out that we did not have a rule on that. The concept of what the client gets to control about a case and what the lawyer gets to control about a case, the allocation of authority, was variously set forth in the Constitution, the Penal Code, and Supreme Court precedent. And I would venture to say basic common sense. Clients come in and say, I've got a problem. I want you to do what you can do legally to fix it. And the lawyer says, within the rules of ethics and law, I will do what I can for you, but I have to make some calls of my own. They did a good job of this, and so it's clear who gets to call the shots. One of the best things they did, which is a little, I think, easy to ignore, is they enshrined in the rule the ability of a lawyer to undertake limited scope representation. Now, some of you might not know what that is, but in former times, it was maybe risky, not forbidden, but risky for a lawyer to say, look, you've got a problem like an unlawful, an eviction, an unlawful detainer, you're a tenant. I can't represent you at trial, but I'll go with you to the settlement conference and I'll try and make sure you understand everything that they're offering for you to settle. That used to be something you could do based on case law, local practice, but now it's enshrined in the rule, and it's a big issue for folks who want to provide limited scope, provide access to justice, but can't afford that they can't afford to take on clients for the whole case because there's no money to pay them. In addition, the new rule carries forward our old concept enshrined in former Rule 3-210 that a member shall not advise the violation of any law, but you can take appropriate steps to test in good faith the validity of any law or rule of a tribunal. Next rule.
Okay. Rule 1.8.2, use of a current client's information. We give this one a grade A. This is it. This is the whole thing, a clear winner. Every jurisdiction except California has adopted some version of this rule. 35 jurisdictions have adopted Model Rule 1A, Paragraph B verbatim. 12 jurisdictions have adopted the rules substantially similar to this rule. And we're going to go over it in further when we address opinion number 2021-205. Business and Professions Code section 6068 states that it is the duty of an attorney to do all of the following, and including to maintain inviolate the confidence and at every peril to himself or herself to preserve the secrets of his or her client. This talks about not disclosing information to the disadvantage of a current client. We weren't sure what that meant. I did look, though, back to the former to the comment to the former rule where it talks about disadvantage, and it talks about using the example of a lawyer who learns, for instance, a governmental agency's interpretation of legislation during the representation of one client could properly use that information for the second client to the benefit of that other client. That would not be a disadvantage to the first client. So that's an example that they use. So maybe disadvantage does become more understandable. Next slide.
Yeah, so just to get back to that, first of all, I like I love the language of at all peril. Isn't that great? I mean, you know, that's right out of maybe even the 19th century. So that's why I'm concerned about this disadvantage. I don't want to be violating the state bar code, right? I mean, that seems like really important, even compared to the rules. At all peril to myself by revealing anything that I've been told in confidence. But at any rate, I guess like all rules, under some circumstances, you can do it. Prospective clients, rule 1.18. So somebody comes to your office and says, hey, I want to talk to you about suing Microsoft, Apple for antitrust. And you say, great, let's sit down. Or maybe more typically, you run into somebody socially and they say, hey, you're a lawyer, and they start telling you their problems. What is a prospective client? I remember when I was in solo practice, anyone down the street might have been coming down the street might have been a prospective client. But it's one who consults with you before you actually open up an attorney-client relationship, but they have the protection of 6068E and Rule 1.6, which is don't tell anybody your client's secrets.
Rule 1.8.11, imputation of prohibitions under rules 1.8.1 to 1.8.9. And we give this also a grade A. This one gets an A because the underlying rules are very clear. The ones 0.8 to 0.9, they are revisions or modifications of the former rules having to do with relationships for clients, such as accepting gifts, aggregate settlements, compensation from other than the client. There's not a really big change there. I think one thing that we found interesting was that they specifically excluded the rule 1.8.10, sexual relations with the current client is not imputed. Otherwise, when the lawyers are associated in the law firm, a prohibition in one of these rules applies to any one of them. I thought it was very interesting that the sexual relations rule was not included. And I don't know what you thought, Judge McBride, but I thought, does that mean all the other lawyers can have sexual relations with that client, or really what does that mean?
I puzzled with that too, but I think it gets to what's called a personal conflict.
Oh,
as
okay.
to one that might be, I don't know, not personal or professional. So, lawyer has sexual relations with current client, and so that client says, I don't care, it's all right, I'm giving up the problem, you can continue living with my administrative person, right? Then that lawyer switches and goes to a firm that's adverse to former client. So I think the lawyer has to be probably screened off, but it doesn't disqualify the firm. That's about as well as I could do on that one. But I agree. It seemed, for me, it needed some more explanation. So I'm going to go to the next slide, which is new rules on imputation of conflict of interest, rules 1.10, 1.11, and 1.12. And I will tell you folks at the 35-minute mark, if you feel like we're wandering in the desert, we are. This is complicated stuff. It's probably easier to recognize it in your office than it is to sit and read a screen and listen to a judge drone on. But if you're going to look at these rules, we got to look at rule 1.7 and the others having to do with conflicts with former client and prospective client. 1.7 being the current client conflict. The old rules, if you're familiar with them, as I know all of you are, kind of put all situations together. So the obligation to a prospective client, a former client, and an existing client were all mushed together in former rules 3.310, avoid adverse interest, and 3.3-320, relationship with other parties, lawyer. What this does primarily, and don't forget our grading system starts out with the premise that all of these rules pass the test, that they conform with the general rules around the United States. Every other jurisdiction in the United States, plus Guam, has this system. So it was about time that California got around to it. So we passed that test by splitting up into different rules, what used to be in the old rules, and maybe refining. That accounts for maybe some of the confusion with why are there so many new rules? They're not new rules, they're just old rules kind of split up. Nothing has changed that much. Although if you read some of the headlines, and like for instance, obligation to report, it can be a little chilling until you calm down and read it and actually analyze what's different.
Okay, so rule 1.7 deals with the concept that loyalty and independent judgment are essential elements to the lawyer's relationship with the client. And this rule does get an A. It's very clear. It's protects the client's. Written disclosure is still required, and written consent also is required. So this rule actually deserves its A.
I agree with you. If you get the part that the other rules on the same topic are just iterative versions with appropriate modifications. So going back to Justices Lambden and Chin, they pointed out, some of the issues with this is that, it gets rid of the old checklist system in the former rules 3-310, which said, you can do this unless, and then if you check the box, business relationship, family relationship. This is more, you examine whether the interest is adverse. One criticism to Presage is the rules that flow from 1.7 are a little fuzzy because 1.7 says adverse to. The other one on prospective client says materially adverse. Lawyers make a lot of money on those distinctions, so I guess that's okay. One other point, Judge Woolard, when you do a disclosure and you get consent, if the client says, I'll waive the conflict, how do you have to do that?
In writing, disclose in writing and get the consent in writing.
And disclose everything. Potential problems, real problems, I mean, you should not, you should spend some time doing this. And this is a heightened standard compared to what the ABA model rule would allow you to do. So these rules that we're going to be through 1.10, imputation of conflicts of interests, the general rule. 1.7, current client, and 1.9, former client, conflicts are imputed to a lawyer's firm. So where does this all come in? It comes in mainly because of lateral movement of lawyers, which we know is far more common than it was even the last time the rules were revised substantially in '92. It has to do with government lawyers going into practice, which is not a new deal. And then it's, there have been a lot of judges and other neutrals that go back into an active litigation or practice. So this imputation rule means you hire somebody with a problem, not a problem, but a disqualifying former issue having to do with representation. So if you hire me, that's a bad analogy because I'm a judge. If you hire a lateral or you hire a government lawyer, their conflicts become your conflicts, unless you take the step of creating an ethical screen. Justice Chin explained to us that used to be referred to as the Chinese wall, and he single-handedly knocked it down in an opinion. So I guess that's why he's on the Supreme Court. So the prohibition based on the personal interest of a client, that doesn't count. So that means, I guess if the client had sex with somebody, I guess if the new lawyer had sex with somebody, and I don't know. At any rate, personal conflict, I can't figure that out. Maybe it's my Catholic upbringing, but I just get all nervous around this sex stuff. So anyway, personal conflicts don't count, but the typical one is they represented a lawyer. They had a trial with the former client. And they come over. You can't go against the former client unless the client waives the conflict in writing. Good luck. How often does that happen? Or you hire a lawyer that did not substantially participate in the same or a substantially related matter. So if the lawyer didn't do the trial, but appeared in court to say my partner can't make it to to this discovery, can we continue it? That's not substantial participation. What if you hire staff? Okay. A good paralegal is probably worth a first-year associate. I don't know. I mean, somebody who knows where the courthouse can get documents out, can handle e-discovery. They're probably, I haven't been in business a long time, but they're worth their weight in gold. There's no direct imputation from hiring the most high-powered paralegal you can find from a competitor firm. But if that paralegal, staff member, research lawyer, whatever they are, research clerk, I guess would be better, has worked on the case, I think you got to be careful. I'm not positive what rule would be triggered, but the comments say, be careful. So who am I to argue with the comments? They were written by a Hall committee. All right. Judge Woolard, do you want to take up
Yes.
government officials joining
I
private
will.
practice?
Rule 1.11, special conflicts of interest for former and current government officials and employees. This rule talks about the relationship when the lawyer in the governmental entity goes to private practice, or the private practice lawyer moves into a governmental entity position. the lawyer carries with him or her the conflicts that can be then imputed to the law firm. And as Judge McBride discussed, you can avoid this by putting up a proper and timely ethical screen to avoid the imputation of the conflict. One of the things I found very interesting about this was the prohibition of the use of confidential government information about a person. And where a government lawyer or official acquired information that a lawyer knows is confidential governmental information about a person, the lawyer may not represent a private client whose interests are adverse to that person in a matter in which the information could be used to the material disadvantage of that person. Confidential government information means information that has been obtained under government authority. The government is prohibited by law from disclosing to the public or has a legal privilege not to disclose, and this information is not otherwise available to the public. A lawyer serving as a public official or employee may participate in a matter in which the lawyer participated personally and substantially while in private practice or non-government employment only if first, the government agency gives its informed written consent, and second, the former client gives its informed written consent. And I don't know how often that happens.
Sounds like an awful lot of paperwork to hire a third-year associate. But, all right, so next slide. So former judge. Oh, that sounds like us. So if you're a former judge, arbitrator, mediator, or other third-party neutral, I wonder what those are, but that's okay. A lawyer who is that shall not represent anyone in connection with a matter in which the lawyer participated personally and substantially as a judge or other adjudicative officer, staff attorney, or law clerk to such person as an arbitrator, mediator. Okay. Unless everybody gives informed written consent. So do you mind if the judge comes to court and represents us in the case that the judge tried to settle? Yeah, I don't think so. So here's a good one. While you're officiating as a judge, arbitrator, or mediator, you can't distribute your resume to, everybody says, oh boy, you did a great job. You're looking for a higher paying job. You can't do that. If that's not self-evident and common sense, but it's not a bad idea to have in a rule. Here's the part that I guess my worst self could get a little angry about. So if you're a former judge and you try to settle a case or cases, maybe you had a series of cases, you cannot be screened. Everybody else in the world can be screened. Screen. Oh, that's okay. We keep old Bob. He has a separate office, up in the wilds of Oregon. We never tell him anything when that case is around. But a judge cannot be screened if they carry with them an imputed conflict. So that means the whole firm's out. The whole firm, worldwide. I guess we all knew judges were potentially toxic, but now we have an absolute on the ground reason. So let's just calm down. I'm talking to myself. The policy here is obviously if you were acting as a settlement judge or a mediator and received confidential information, you have no business, you can't be screened. The public policy it looks horrible to say, well, the former judge who spent 6 days trying to beat you into submission into a settlement can now represent one of the parties. That's or the firm that judge joined. So I'm going to give it a B, despite my initial somewhat bad reaction to it. Judge Woolard.
Okay, let's go to Rule 2.1.
One of my favorites. I'm so happy you got this one.
2.1, the lawyer as an advisor. And we have on the screen the entire rule and the entire comments. This is the winner of the special category best comments. We've given it a B. It states, in representing a client, a lawyer shall exercise independent professional judgment and render candid advice. And the comment number 1 seems to indicate it's not an ethical violation to be a busybody if it appears to be in your client's interests. The second comment talks about, although it's cleverly phrased, candid advice seems to be limited to legal advice and more morality and all that is optional if it's relevant. And I looked at this and I wondered if this perhaps is the rule that makes the lawyer your parent. And then I wondered, is this a shield in case the client gets offended and wants to report the lawyer to the state bar for giving them bad advice that doesn't necessarily pertain to their case? I thought this was a very interesting rule.
So Charlotte, I think once again, we've got go along with the crowd mentality here. If the ABA has this rule and the majority of other states have adopted, we have to have it. And I had the same reaction to you. I said, this is kind of silly, right? If this is not common sense, I don't know what is. But then I started thinking like a lawyer. And, maybe a client who took a course of action that was perfectly legal and ethical for you to carry out will later on say, gosh, I didn't realize in acquiring a multinational that I would cause a tribe of endangered indigenous people to be wiped out. Why didn't you tell me? And your defense is, well, you didn't ask me about the morality of it, and I didn't feel that you wanted the advice. But well, whatever. I'll give it a B because I love the comments. Next slide, please. This is another one that I just think we go along with the crowd. It's a nice rule to have. It's not bad. So you're acting as a third party neutral, and I don't know. Suppose you've never done it before, but suppose you're a judge just off the bench, and you're starting your practice, and you get 2 unrepresented parties in a difficult case. You should tell them, I don't represent you. The other person has a lawyer and I'm in the room with you, but I'm not your lawyer. I'll be talking about the law. To me, it just comes naturally. It's, hello, how are you? My name is, right? But here it is in the rule. And then it says, basically, if they don't get it, you have to draw them a picture. Okay. Now maybe we're getting into some of the mental capacity issues we'll be talking about later. But I give this one a good grade, not because of the common sense embodied in the rule, but the comment says, watch out. If you do take a job as a neutral, you're not regularly on the business, you may be subjecting yourself to a whole bunch of other rules. Like if you take a pro tem job at the court, you could be in front of the committee, you're under the commission, the canons of ethics for judges. Depending on who you sign up with, there might be all kinds of disclosure rules for arbitrators, and you could get into trouble that way. So the comment saves the whole thing. Next slide.
Okay, 3.2, delay of litigation. We give this a grade C. This is a strong contender as the rule most likely to open a can of worms. The rule is very brief. You shall not use means that have no substantial purpose other than to delay or prolong the proceeding or to cause needless expense. This is soon to be a favorite rule among judges and tight-fisted clients. Who has standing to complain? Opposing counsel or the judge that decides you're taking too long in a trial and hopes you'll lose the jury quorum? The you do something to delay and it's in the client's interest, but then the billing issue arises and you're accused of padding the bill. Rule 1.3 talks about reasonable diligence, which means that a lawyer acts with commitment and dedication to the interests of the client and does not neglect or disregard or unduly delay a legal matter entrusted to the lawyer. So with respect to reasonable diligence, we understand that, but how about Rule 1.2? The client controls the objectives of the representation. Suppose the client has a legitimate reason to delay. So I think this does open the can of worms.
So, Judge, we were both we were both prosecutors at one point, and we were both in the criminal division at one point. I'm going to say that you agree with me that delay in a criminal prosecution is frequently the defendant's best friend.
Yep.
And I'm going to venture a guess that there are many very ethical lawyers who use means that have no substantial purpose other than to delay or prolong the proceedings, right?
I think so.
And they do a good job for their client. So,
yeah,
are crabby old judges going to be able to complain to the state bar that criminal defense lawyers are moving too slowly? And what if it's to the benefit of your? I think this is a total can of worms. We said it. We don't need to beat it to death. That and if you were attending this morning, Justices Chin and Lambden, although neither one of them seen the inside of a real courtroom for a long time, spent an awful lot of time on what diligence means. So between these two rules, I feel sorry for the state bar investigators. There could be this could be a fad. So at any rate, I'm going to give it a C because it's just going to cause a lot of trouble and not produce any discipline examples that other lawyers can guide their behavior by. Next slide, 3.9. This is another doozy. If you represent a client in a non-adjudicative matter before a legislative body, you have to tell the body that you represent someone. How many times does a lawyer, what the lawyer comes in and goes to a city council meeting and stands up and says, I think that building this high rise would be the best thing that ever happened to downtown San Francisco, and dresses up, kind of like a South of Market bicycle advocate artist? Is that what we're trying to cure here? That lawyers, wolves in sheep's clothing, showing up, pretending they're not a lawyer? I'm not sure. And is it so that the legislative body can find out who's the real bête noire, who is the hand behind it? No, you don't have to identify your client. All you do is you stand at this podium and you say, hi, my name's McBride. I represent a client. We want that high-rise built. I don't get it. And then it's only if you're presenting evidence or argument. Well, what does that mean? I guess when the witness is sworn, you're presenting evidence. If you say, I want you to consider this affidavit, that's evidence. But argument? I don't understand this rule. I think it's because everybody has one. I don't know it's going to cause any trouble, but it's a mystery to me where this problem happened and why somebody devoted the time to say, yeah, if a lawyer stands up at the podium in front of the city council, they better tell people they're a lawyer. All right. We gave it a B-. After hearing myself talk, it's down to C.
Going back to Rule 4.1, truthfulness in statements to others. This also gets a C-. There's no former rule. It's aspirational. And I kind of thought perhaps we added it because truthfulness always sounds nice, right? truthfulness in statements to others. Of course, lawyers should be truthful. But there's no counterpart to this rule. The rule is straightforward. It says the lawyer shall not knowingly make a false statement of material fact or fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client. Let's go to the next slide, which has the comments. These comments demonstrate the vagueness of this rule. They make the rule seem highly aspirational in contravention of the Supreme Court's directive to not make the rules aspirational. The rule states a goal of the lawyer being truthful in statements to other, but then the comments give wiggle room and examples of, well, the lawyer doesn't absolutely need to be 100% truthful. The document or agreement drafted for the client doesn't necessarily mean everything in it is true. And it seems like with these comments, it boils down to the lawyer shall be truthful, except when the lawyer doesn't have to be truthful. So I think C- is a good grade. It's a generous grade.
Yeah, I don't know that I'm getting more sympathetic or less sympathetic to the commission. I mean, they had their marching orders. They had to come up with rules that meshed with the ABA. So, I mean, let's not be too harsh on the folks who drafted these. But you could never lie in court. That's easy, right? You can't lie to an arbitrator. That's easy.
Right.
Justice Chin and Justice Lambda today said, what about lying in a mediation? And, Justice Lambda, I think, hit the nail on the head the best when he said a lot of mediations are a poker game. It's not that you're not lying, but you're not disclosing material facts. And that's part of the rule. The failure to disclose a material fact can be a violation of this rule. I think we may have missed out on at least a bronze medal on the Can of Worms Awards on this one. But, time will tell. I will say that what research I've done indicates that the state bar, curve of cases or complaints, it's still the same old one: conflict of interest, failure to communicate with the client, incompetence are big ones. And then there's an immense category that doesn't cover lawyers typically, of practicing law without a license. Okay, let's turn to 4.3. This is a good one. So, communicating with an unrepresented person. You cannot state or imply that you are disinterested, and you have to correct any misunderstanding about it. If the interest of the unrepresented person and client, you shall not give legal advice to that person. Right here, if the interest of the unrepresented person and client are in conflict. Okay, so you represent an insurance company and the unrepresented person's lying in a hospital bed with the usual, bandages and casts. That's pretty clear. You have to come in. I think you have to say, I'm a lawyer representing whoever, and I want to settle, and you can't give them legal advice. Should you tell them you're there because the statute of limitations is going to expire in a day? Meaning that the injured party is not going to get any money if they don't do something. I don't know. The one thing you absolutely cannot do is seek to obtain privileged or other confidential information from an unrepresented party, even if you comply with everything else. I'm not disinterested. My client's interests are opposed to yours. I can't give you legal advice. And then the unrepresented person says, well, let me show you this letter from another lawyer, or let me show you what, this document that you recognize as being privileged. You can't ask for it. That's a distinction, because your client could meet with the unrepresented party face to face and say, hey, show me all the stuff you've got that, that may or may not be privileged. It puts your civilian client in a different status than you in the lawsuit. It sets up a unique risk for lawyers who may be compelled to deal with a lot of unrepresented people. I mean, a lot of people have practices where you never actually see the client. It's a corporate, but a lot of people have landlord-tenant practices where they represent a landlord and they deal with unrepresented people who may have, all kinds of challenges, including language. I think this is it's certainly an attempt to get people to toe the line, but there's great risk for lawyers who get close to the line. Next.
Okay, Rule 4.4, duties concerning inadvertently transmitted writings. We give this an A. And top part of the slide is the actual rule. A lawyer who receives privileged writing inadvertently shall refrain from examining the writing any more than is necessary to determine that it is privileged and promptly notify the sender. This is a situation where a lawyer hits send and sends it to the wrong person. The first part of the rule is fine. It's the second part, which was not adopted, Rule 4.4a, which presents some problems. It's vague. And I wondered as I looked at it, what's it doing on this rule? It shows how difficult the job of the commission had in making our rules match. The comment notes that the rule does not address the legal duties of a lawyer who receives a writing that the lawyer knows or reasonably should know may have been inappropriately disclosed by the sending person. In other words, the disclosure of the document was done on purpose. But this rule as it stands, where it's an inadvertent transmittal, it deserves the grade A.
Okay. Next rule that's brand new. Don't forget, these are the brand new rules. 5.1, responsibilities of managerial and supervisory lawyers. I think we've gone over this already today. The basic is that if you're a manager or supervisor of others, and that includes maybe people outside the firm, you might have associated lawyers, but you're running the thing. You have to make reasonable efforts to assure that the lawyers comply with the rules in the state bar. And if you don't, you're responsible for another lawyer's ethics problems if you ratified the conduct or didn't timely take remedial action. When I first heard about this, along with the see something, say something rule, I thought, wow, this is a big change. Then it calmed down. It's not revolutionary. Former Rule 3-110 said that the duties set forth in this rule, which the basic rules, include the duty to supervise the work of subordinate attorneys and non-attorney employees or agents. So once again, we meshed everything together in one rule. As you'll see, they're split apart by the model rules.
Rule 5.2.
Please.
Responsibilities of a subordinate lawyer, which is another can of worms contender. This also deserves a grade A. Basically, the subordinate lawyer, if you see something that you believe is unethical, it's your duty to speak up. Again, see something, say something. A subordinate lawyer does not violate these rules, however, if the lawyer acts in accordance with the supervisory lawyer's reasonable resolution of an arguable question of professional duty. But if you as a subordinate lawyer see something that you believe is in violation of the ethical duties, it's up to you to go speak with the supervisory lawyer. The duties set forth in the rule include the duty to keep abreast in the changes in the law and its practice, including the benefits and risks associated with relevant technology. Done a little bit of searching, and according to the state bar demographics, there are 34,091 lawyers between the ages of 75 and 90. And how many of those are still active is not included in the data. I could just imagine being a newer associate, seeing something that you feel you should say something, and having to go to this much senior lawyer and explain the problem. But we will be discussing the issue of the subordinate lawyer later when we address the opinion number 206.
And Judge Woolard, don't forget, I think it was brought up today and it needs to be emphasized that part of competence is keeping up with technology.
Absolutely.
Yeah, I mean, e-discovery. It was a big novel concept 15 years ago. Now it's like the only way it's done.
Now it's every day.
Yeah. So rule 5.3 next. Once again, training and supervision. So non-lawyer assistants, same rule, reasonable assurances. You have to do stuff that will make sure that your people who are not lawyers understand that they have to follow the same legal ethics, basically. And you're responsible if you ratify the conduct. So basically, train and supervise. Next. I have two in a row.
You have two in a row.
I'm calling the Labor Department. So the Supreme Court did not approve a proposed rule that I'm sure the committee spent a lot of time on. 1.14, client with diminished capacity. But it wasn't for lack of interest in the topic. I think it is a persistent topic that's not going away. Basically, my read on it is that the failure to adopt that rule was not because people thought, oh, we have enough out there to guide people. I think it's just too complicated to deal with all of the issues in California law. There are two opinions we're going to be dealing with later. Right now, let's go back and talk about prospective clients. But before we do that, what are these advisory opinions? What are these opinions on ethics? Judge Woolard.
They're not binding, but they do set up their advisory opinions providing ethical propriety of hypothetical attorney conduct. Lawyers are encouraged to consult them for guidance, and they also have been cited by the California courts in analyzing professional responsibility issues. So although they're not binding, they're very important, they're very instructive, and we certainly have an awful lot of them. They come out periodically. It's a good idea to keep up with them, which is why we're going to turn to the ones from 2021, the most recent ones. The first opinion, 205, talks about the prospective client who provides confidential information to an interviewing lawyer. And we talk about what the interviewing lawyer must do, whether ethical screening is available under certain circumstances if you don't take the prospective client's case, to what extent can the prospective client give advance written consent to permit other lawyers in the interviewing lawyer's law firm to be adverse to a former prospective client. So let's go to the next slide.
So rule 1.18, we're back to that one. Prospective client, somebody who comes into your office and says, hey, I want to talk about my divorce. And you spend 5 minutes and they say, well, you're too expensive, and they leave. And later on, the spouse comes in and says, I'm getting divorced, I want to hire you. Do you have to say, oh, I'm conflicted out? Maybe not. So a prospective client is one who consults, for you to take a case, but they must have a good faith intention to seek advice or representation and a reasonable expectation that the lawyer is willing to discuss the possibility. So there's no shopping around town to create conflicts with all the best lawyers in town. But, do you want to be defending this particular kind of a claim? If you do sit down with a prospective client who meets this, the rules are invoked. They've got a lot of protection. And I think we're going to cover that in the next slide. I am. Okay. So the prospective plan is all the protection of 6068E, which is the all peril statute, and 1.6, which is, I love that rule, don't violate 6068. So both sides can consent. So I know what'll happen. The former spouse will give written consent. The two spouses will agree with a written consent that the other lawyer can I don't think that's going to happen. Okay. So what can happen is if you have a good faith client come in prospective and there turns out to be a problem that the lawyer doesn't retain you or the client doesn't retain the lawyer, then the firm, not the individual lawyer, but the firm can take on representation if the original lawyer took reasonable measures to avoid exposure of information more than necessary to determine, like, is there a conflict? And took no more information than reasonably necessary to make the determination about taking the case. Then, if that happened, the firm can represent an adverse party if the interviewing lawyer is timely, ethically screened. And what that means, I don't know in detail, but cut off from the case, does not participate in the matter, and earns no part of the fee. Also, written notice has to be given to the prospective client who walked out without hiring you timely so they can evaluate whether or not these rules have been followed. Next slide.
So we have,
Oh, sorry.
we
I
have,
No, I think it's still me on.
excuse me? I think we skipped a slide, but you may have covered it already.
Yeah, I think we skipped a slide. Doesn't matter. Let's keep going.
Let's go to the scenarios. They have,
Yeah, let's get to some real people.
I think this is a special way of saying these are hypotheticals. So the first scenario, actually all scenarios, the person, we'll call PC, consults with a lawyer about retaining the lawyer and the lawyer's firm to prosecute a misappropriation of trade secrets claim against its competitor. The lawyer conducts an interview to determine whether the lawyer can and should represent the PC. Next slide. At the outset of the interview, the lawyer advises PC the lawyer has not agreed to represent the PC, but then does not provide the PC with guidance or caution about what the PC should disclose to the lawyer. Instead, the lawyer asks open-ended questions about the business, about the claims against the competitor. PC provides confidential information about the merits. The lawyer declines the case. Competitor seeks to retain the law firm. The law firm is prepared to erect an ethical screen. May the law firm represent the competitor.
Who are you asking? Me?
I'm asking you, but I don't see the answer on the screen yet.
How do I?
There it
No,
is.
well, you have to hide it. You have to hide the answer to watch me.
Oh, to watch you reach the answer. Okay.
But you need the business. So yeah, no, you can't. So I like the way this is set up. Like you're sitting in your office in a big firm and somebody sets up an appointment with his client or potential client, PC here. And you're all excited because you love trade secret cases and all that. And then you just talk about everything under the sun, right? Everything. How much money is the company worth? Maybe that happens that way, but I think in smaller practices, the way it happens is you run into somebody. They tell you their whole life story, including their great trade secrets case, which you think, how can this guy that I met, my sister-in-law's house possibly have a good, and it turns out it sounds really good. And then you find out there's a conflict and you've told everybody in the firm that it's wonderful. That's the way it typically arises. But under these rules, if you want, particularly in a larger firm, if you're going to have these interviews where you're not sure, even if they're going to pass conflict check, let alone are you going to take the case. Constrain the interview. Make sure that the potential client knows we're not in an attorney-client relationship yet. Tell me only, it's a structured questioning. Don't let them open up. The answer is you cannot, you and your firm cannot take it. Screening's not going to work. So this lawyer followed the advice. They took this course and followed the advice. The lawyer tells the potential client, listen, we're not in an agreement yet. The interview is only to decide whether we have a conflict. And the lawyer says, don't tell me anything not reasonably necessary to assist me in finding out if there's a conflict. The conflict search reveals that the prospective client is a competitor of an existing client. And even at that moment, your firm is advising competitor about an upcoming public offer. The fact of this potential lawsuit could be a disaster for the upcoming public offering. Needless to say, the firm declines representation. Judge Woolard, can you run down the hall and tell your partner, boy, we better tell competitor company about this threatened lawsuit?
Absolutely not. So that would be a no.
Well,
why?
What about your duty of loyalty? Competitor.
Oh, well, you've got a duty of loyalty and confidentiality, not only to your existing client, but also to your prospective client. And the lawyer believes that use or disclosure of the fact of the possible suit could harm the prospective client and could also affect the client's plan of public offering. So no, you cannot run down the hall and go tell your current client, watch out, here comes a lawsuit.
No, I bet you dentists don't have problems like this.
That's why we became lawyers.
All right. So you notice at the outset that lawyer, I was really careful. I took the McBride Woolard course. I had a very constrained interview. Probably that's why the client said, I'm getting out of here. But the conflict check may the lawyer represent the competitor, may the firm represent the competitor if the potential client later sues competitor firm.
Yes. The lawyer can represent the competitor. The fact of the lawsuit is now immaterial because the lawsuit has been filed and it's now public. And the lawyer received only information related to a conflict check. I think the comment, or there is some portion of this opinion that says if the lawyer were nervous for some reason, they could also erect an ethical screen for the law firm to represent the competitor. But under the opinion with these particular facts, the lawyer may represent the competitor if the PC later sues.
So I think the key is how much information was given. Under the facts here, nothing more than do a conflict check. Apparently no merits investigation. So the lawyer can do it. If the merits were gotten into, then we start getting into whether the interviewing lawyer can be screened. All right. Next slide.
2B has the same facts as scenario 2A, except that during the preliminary discussion to determine whether there would be a conflict, and despite the lawyer's repeated admonitions, the PC volunteers confidential information relating to the claim that if disclosed or used for the competitor's benefit would be damaging to the PC's case against the competitor. And also the lawyer was very careful. None of his questions would have naturally elicited such information. So would the law firm be prohibited from representing competitor under these facts?
No, I'm going to say no, but you have to comply with Rule 1.18D2. so basically, because the lawyer did a good job of confining the original interview and the potential client was a blabbermouth, the lawyer could say to other people in the firm, look, you should take this case, but I'm out. I know too much. And there has to be a timely, effective ethical screen. Now, in a big firm, that's probably doable. Move off the floor where the case is being worked, put up some kind of block on the file so deliberate or inadvertent access. Obviously, in a smaller firm where there's 6 people, in offices, it might be a lot tougher to set up this ethical screen. In addition, written notice has to be given to the prospective client so that the prospective client can ascertain compliance with the provisions of the rule. Now, there's a little. How does the prospective client ascertain compliance? Do they come and inspect where the lawyer is? Do they get to look at the block on the file? I mean, I don't know how that's going to work, but what they're trying to do is accomplish keeping big law firms in business rather than having them conflicted because somebody in the Seattle office talked to somebody. Prospective client cleared the conflict check, and the lawyer engaged in a limited inquiry into the prospective client's ability to pay hourly rates. Continues to caution the potential client, there's no attorney-client relationship yet. Don't tell me more than I need to know. But we have to talk about whether you can afford what a contingency would be like. So the lawyer gets into a carefully structured, tell me all about the claim and the damages. Lawyer decides to reject the case and wisely tells no one else in the firm and doesn't memorialize in any database the information that he got about the potential client. Can the lawyer represent the competitor?
Well, no, I think that should be pretty self-evident. The lawyer knows too much.
That was a softball. That was a softball.
I think.
How about the firm?
The firm, yes, if they set up an ethical screen, they could do it, but definitely not the lawyer.
Okay, let's get moving because we're not going to get to mental health, and I feel the need for that.
We need mental health.
Yes. Next slide.
So scenario 4 is what they call a beauty contest. The PC has cleared the conflicts, but is interviewing other law firms and wants a little bit of work done from our law firm to find out which law firm the PC would like to hire. And so the PC gives all sorts of material information, confidential information, so the lawyer can provide a memorandum analyzing the case and setting up a proposed strategy and budget. But then the PC doesn't retain the law firm. The competitor subsequently seeks to hire the law firm. So what circumstances would enable the law firm to represent the competitor?
Well, I think the safest way to go would be at the stage that the irritating potential client says, give me about 40 hours of free work on the case. You say, hey, fine, but there's a quid pro quo. So we'll perform the evaluation at no charge as long as potential client agrees that if we don't get the job, we will be free to take on clients adverse to potential client in the same or substantially related matters on behalf of the one you want to sue. That advance waiver should be in writing. And it would be nice if probably potential client had in-house counsel to review it. I'm not sure you want your sister-in-law's best friend who has a claim getting into some advance waiver. But those are the circumstances I can see. If there's no waiver, forget it. You can't do work product for one client and then turn around and represent the opponent in a same or substantially related matter. Next slide.
Okay, we're switching to opinion 206 and our first diminished capacity, the one where the senior lawyer unfortunately is suffering from diminished capacity and subordinate lawyer is sort of along for the ride. We previously called this a can of worms contender. I consider it to be a contender for being between a rock and a hard place, but let's go to the next slide and take a look at it. The unfortunate tale of the impaired lawyer and the subordinate lawyer. The impaired lawyer is a senior partner and lead counsel for a longtime client on a litigation matter set to begin trial in about 150 days. The subordinate lawyer is a fifth-year associate assigned to assist with client's matter and a member of the litigation team since the case's inception. I suspect that the subordinate lawyer is probably doing quite a bit of the legwork on this case, although the subordinate lawyer does not have any real direct client contact. That's up to the impaired lawyer, who is the senior, and that's his longtime client. Unfortunately, the impaired lawyer has recently exhibited signs of mental impairment. He went to a motion for summary judgment to oppose the motion and floundered around in court and could not argue it. And the associate subordinate lawyer had to argue the motion, eventually did win. The impaired lawyer misses meetings, doesn't respond timely to the client, and discusses facts and strategies that don't apply to the case. The impaired lawyer is argumentative when questioned about, well, why aren't your facts and strategies applying to the case? The impaired lawyer does not transmit an offer to the client, and then it expires. The subordinate lawyer directly raised the ethical concerns with the impaired lawyer, mentioned the duties of competence, diligence, communication, etc., and tells the impaired lawyer that he's no longer competent to be lead counsel. The impaired lawyer denies the problems, mentions, I've got a large caseload and I'm undergoing a contentious divorce. He admonishes the subordinate and says, don't raise this with the client. You know, we're worried the client could lose confidence in the firm, and financial and reputational harm to the firm could ensue. So subordinate lawyer got nowhere directly confronting the impaired lawyer. So what should the subordinate lawyer do? There were two scenarios that are set up. The first scenario is both are in a mega firm, 850 lawyers, international, has executive committee, all sorts of committees. And the second scenario is both the impaired lawyer and the subordinate lawyer are the only lawyers in the firm. It's a really small firm. So let's go to the next slide. So first, the responsibility of the impaired lawyer. And the impaired lawyer has many, many responsibilities. Just because the lawyer is impaired doesn't mean that the lawyer has any lesser responsibility than before. Mental impairment is no excuse. Personal problems, a heavy caseload, contentious divorce, no excuse. The duty of competence, reasonable diligence, client communication, disclosing all the facts and circumstances so the client can make an intelligent decision. The client is supposed to be alerted to significant developments in the case. Failure to perform legal services competently and failure to communicate with the client. Those are serious and the duties remain. The lawyer cannot put the lawyer's personal reputational competence ahead of the client's interest. If the lawyer is impaired, the lawyer cannot represent the client adequately. The analysis is fact dependent upon whether the impaired lawyer's personal interest conflicts and might even be imputed to the other lawyers of the firm if their interests avoiding a malpractice suit or a fee dispute with the client or reputational harm would prevent their communication with the client, or if they preferred to hide the impaired lawyer's conduct or misconduct. So the impaired lawyer may end up needing to terminate his representation. The lawyers in the firm might be able to continue on, but they need to adequately disclose to the client what has occurred. But then there's also some confidentiality that needs to be protected for the impaired lawyer. For instance, you could use as an example that he had problems with the motion for summary judgment hearing. That would be something you could discuss, but you really need to be careful about disclosing the personal mental issues that the lawyer may be undergoing.
So Judge Woolard, I have a question on that. So impaired lawyer says, I'm going, you're a colleague, you say, hey, you really botched that argument. And lawyer says, yeah, I know, contentious divorce. There's no confidentiality on the divorce. You can tell the client about that, right?
Sure, you can say, you could talk about that, yes, but I think they're more worried about HIPAA stuff, that was my impression.
The protected stuff would be if the impaired lawyer says, look, I'm in the later stages of some kind of dementia, but don't tell anybody. Then you've got to finesse with the client, right?
Yeah, I wouldn't say he's in the latter stages or early stages of dementia. I would stick to the facts that are publicly known. The facts
that's what I'm saying is you can't tell the client about the dementia. Okay.
No.
Right. I mean, there's no special rules for us. It's just general rules of privacy out there, right?
Right.
Yeah. Okay. Were you going to ask me a question?
Not yet. I'm going to ask you questions later.
All right.
So I think you're going to talk about other lawyers.
Oh, is this me now?
Just the top part.
Just okay. All right. So this is getting around the firm, right? The associate who went to the hearing, asked to report and whatever. So it's getting around the firm, or it's just observed, right? The other lawyers have to take reasonable measures. Obviously, in a big firm, it's a little easier because there's a management committee and a risk management committee. You kick it upstairs. You say, look, Fred, we've got to do something. But it doesn't stop with sending the memo up to the managing partner. You got to make sure that reasonable steps are being taken. So if Fred goes off to court to pick a jury, you're probably pretty sure that reasonable steps haven't been taken. Obviously, the rule 5.1 supervising lawyers, they have to confront Fred. They have to, they have to say, look, how bad is this? They have to do an investigation. They have to examine the harm to the client. He's breached a lot of duties, but mainly that expired settlement offer that's a violation of the State Bar Act. So, I mean, immediately the client has to be put on notice of significant developments. That would be, I would say, a significant development, and also a potential malpractice claim. And the firm, if they're in the posture of representing a client where there's probably already been malpractice at least set up, are they impaired from vigorous representation because they've got their own interest at stake? All of this is what his colleagues and the the management of the firm should be doing. Paramount has to be doing everything reasonable to protect the client's interests. absolutely secondary to the point of vanishing are the interest in the firm's reputation, revenue, etc. So what about the poor associate?
Well, we've talked about Rule 5.2, responsibilities of the subordinate lawyer, and she may not follow an order to engage in conduct when there's no argument that it's legally permissible. She has duty to take reasonable remedial measures to protect the client. She may communicate with other supervisory lawyers where she perceives this ethical problem, and where she believes that notifying other lawyers in the firm would be ineffective or in an emergency situation would not be feasible. Subordinates should take action as may be required to preserve the client's interests. The client remains number one.
So I think we can probably blow through the next slide. Basically, in a firm of any size, it's got a committee or management. Everybody goes through them, and this makes sure that the right thing is done. In a small firm where the associate is the only other employee, it's not so easy. If the confrontation doesn't work, hey, Fred, you got to get some help. We got to associate somebody. And Fred says, don't communicate with the client about anything. You just go about your business or you're fired. In each case, the lawyers have an independent obligation to communicate directly with the client. If small firm, there's nothing else they can do. Big firm, you're just not satisfied that reasonable measures are taken to address the misconduct and prevent or cure the harm.
So let's go to 207, which is the third opinion. And
right,
this is where
right.
You
Slide
have the
50, I think. 5-0. There we go.
You would have the client who is undergoing diminished capacity. And this opinion is based on California law. So let's go to the next slide. So capacity in general, what is it? Which is a good question. It's not defined in the rules of professional conduct. We find some guidance. I've put some up here, found in the probate code. The presumption of capacity must be overcome by affirmative evidence showing a lack of capacity. The presumption is not overcome by a diagnosis of a mental or physical disorder. There must be affirmative evidence of a deficit in one or more of the person's mental functions, which significantly impairs the person's ability to understand and appreciate the consequences of their actions with regard to the act or decision in question. And the probate code looks at the client's alertness and attention, information processing, thought processes, ability to modulate mood and affect, and marital and testamentary capacity are determined by different and lower standards. Capacity is decided on a case-by-case basis.
So this paragraph, I think, is really some. So you have a client that you know has diminished capacity. It's not, we're guessing. This is somebody who's had a traumatic brain injury or has some kind of illness that affects their capacity to reason, understand, all that. The lawyer shall, as far as reasonably possible, maintain a normal client-lawyer relationship. So the client makes the decisions normally reserved to the client, and the lawyer carries that out. That's Rule 2.1 or 1.2, sorry. Where does the client's, decisions that were reserved to him come in? Well, the formation and termination of the relationship, lawyer to client. Anything that requires their informed consent. So by my count, there's 7 rules implicated in that. 7 rules of professional conduct. So you have this person who has difficulty understanding you. You have a person who has difficulty remembering what they've been told. You have a client with all kinds of problems. You may not even understand all the problems, even though you know the basics. So then it comes to competence involves maybe calling in other knowledgeable people to assist you. So maybe the client understands or understood at one point I have a traumatic brain injury. You can share my medical records with consultants. Maybe client has never done that. In the former case, it's easy. You can say, hey, client, I'm going to talk to your doctor or another doctor about what I need to do. You may have to call an expert in and say, my client has a traumatic brain injury. That's known. I can't tell you anything else. Help me out. The goal, obviously, is to maintain as normal a relationship as possible. Boy, could that be tough.
Very challenging.
Next slide.
The duties of competence and communication. The lawyer must exercise the learning, skill, and mental and emotional and physical ability reasonably necessary to provide legal services called for in the representation. The duty may require the lawyer to consider measures to assist the client in decision-making. For instance, if you talk to your clients in a coffee shop, maybe you don't talk to the client there because it's too noisy. Maybe you go to a quiet place. Communicate more slowly or in writing, take extra time, or sessions. Schedule time when the client is less fatigued and more lucid or receptive. In communication, the client's diminished capacity may impact the lawyer's duty. It may blunt the client's understanding of the client's own interests and or objectives, or make it more reasonable or more difficult to communicate them to third persons. So the duties don't go away just because the client is incapacitated or has diminished capacity. If anything, the lawyer should be adjusting what the lawyer does in order to meet the challenges. Next slide.
So let's get back to one of the fundamentals of any attorney-client relationship, duty of loyalty. You have to act solely in the client's interests and protect the client in every possible way. Your primary duty is to effectuate the client's wishes and make sure, to the extent possible, the client understands the options and the legal and practical implications of whatever course of action is ultimately chosen. That's pretty easy. But when you have a client with really bad decision-making, other people may have an interest in shaping your tactics. The classic would be the aging guy who decides to disinherit his loving children because there's a new show in town and one of the dancers has caught his attention. So everything will go to this dancer. That's right out of a 1950s movie, but I think it happens a lot. So you may have kids saying, hey, what's going on here? Your duty is not to the beneficiaries, to the third parties, to the wife, whoever may have a very legitimate interest in bad decisions. It's to the client. So in that sense, you have to put aside, stereotypes about mental impairment, mental illness. You have to use independent judges to judgment to follow the client's wishes, and what a delicate balance. Duty of non-discrimination. In representing a client or terminating or refusing to accept representation, a lawyer shall not unlawfully discriminate against persons on the basis of protected characteristics. 8.41a. Physical disability and mental disability are covered. Under the ADA, law offices are places of public accommodation. And if my folks are listening, probably mediation suites are too. If you're representing clients with diminished capacity, you should consider whether the ADA or other similar laws require accommodations. The Unruh Act is the mirror, not the mirror image, but the local version. 15B prohibits discrimination against persons based on disability and medical condition. They're entitled to full equal accommodations and advantages. Now, I've never heard of this happening, but it's certainly something that if you really have nothing else to worry about, you can worry about that.
So taking proactive action, authority, confidentiality, and loyalty, they remain. Absent a final judicial determination of incapacity, a lawyer's reasonable belief that a client is incapacitated should not by itself terminate a lawyer's authority to take protective action in the client's best interest if such action is in the scope of representation. And information about the client's diminished capacity will often be kept confidential and protected from disclosure. So does a lawyer continue to have an agency relationship with the diminished client that confers authority to take proactive measures in the client's best interest? There's very little California law in the question, and the application of the common law rule found in the restatement that incapacity of the principal terminates the agency relationship is doubtful here. The diminished client continues to have rights that need protection, and the lawyer has duties. The client may be able to participate to some extent, and the lawyer should maintain, as far as possible, a normal attorney-client relationship in the client's best interest in exercising continuing authority. If the client lacks capacity to give consent to the disclosure of confidential information regarding the diminished capacity, the client is unavailable, or the client declines to give consent, the lawyer may not make such a disclosure. The duty of confidentiality combines with the duty of loyalty to bar the lawyer from initiating a conservatorship proceeding against a client without the client's informed written consent, even if the lawyer believes the conservatorship standard has been met and it would be in the client's best interest.
Next slide. So in some jurisdictions, it's fairly easy to get advance consent for various things. Not so much in California, but we have Rule 1.2, which permits advance consent to give, to have a release of confidential information. You can imagine a lot of estate planners with older people coming in as part of their deal say, look, might be a good idea. It has to be revocable at any time, should be in a separate written document. We're kind of running out of time, and I really want to get to that last scenario, but let's see what we can do. Are we at scenarios? Yes.
Yeah, we're in scenarios.
Let's do number 3 first. I think it's the most tragic.
Okay, so the lawyer is representing a client in a personal injury action and has a very large recovery. The client, who is exhibiting signs of diminished capacity, approaches a lawyer about assisting with the paperwork to make a generous loan to his nephew, who happens to be a felon. The lawyer reasonably believes the client lacks capacity to enter into a loan transaction. He calls the client to tell him, but the nephew answers the phone, says he's now got power of attorney over the client. The lawyer reasonably believes the nephew lacks authority to act for the client, and there is a threat of financial harm due to the client's diminished capacity. What, if any, measures may the lawyer ethically take to protect the client from harm?
So the client is definitely threatened with substantial harm at the nephew's hands. The lawyer does not have to accept this. So I'm, the attorney, I have power of attorney, and can continue to make efforts to get in direct contact with the client to give the appropriate advice, which would be, get rid of this nephew. If, however, the lawyer is cut off successfully from his client, the lawyer may be powerless. California's confidentiality rules do not permit the lawyer to disclose information about clients' condition to third parties without clients' informed consent. Now, I'd like to just say that if this was a litigated personal injury case where there's a public record of the problems, the lawyer may have an out. So it's not confidential if it's been exposed in a courtroom, maybe. But if this has been a settlement, there's been no public information out there, the lawyer can't do anything. The lawyer may have their hands tied given California's very, very tight rules on confidentiality and prohibition for the lawyer seeking a conservatorship. The lawyer may have to just sit and watch. Now, I'm going to say, without advocating or recommending, that this rule would probably be frequently broken under these circumstances. I think a lot of really good ethical lawyers would make a lot of phone calls to concerned people, revealing confidential information about the client to prevent the harm. But who knows? All right.
I'd like to go to scenario 4, though.
Long-term client, the lawyer has prepared an estate plan. Lawyer knows the client pretty well and sees the client is really in decline. The lawyer wants a new will cutting out children in favor of the younger companion who has recently moved in with the client. Lawyer reasonably, with permission, asks around lawyers, close associates, family member, and reasonably concludes that the client lacks testamentary capacity, but for the diminishment in capacity, would not make the new plan, would not cut the kids out. May lawyer ethically prepare the new estate plan?
Okay, and the quick answer is no. The client has consented to the lawyer making reasonable inquiries into the client's capacity and concluded the client lacks even the low capacity required for testamentary decisions, and the client is subject to a substantial risk of undue influence. At a minimum, the lawyer has a duty to provide the client with advice regarding the lawyer's conclusions. With the client's informed written consent, the lawyer could involve others, whether experts or family members, to assist the client in understanding that advice. But if the client decides to accept the lawyer's advice, the lawyer doesn't need to go further. If the client declines the lawyer's advice, the lawyer should decline to prepare the will.
All right. So, Judge Woolard, I think these people are tired. Maybe we should let them go home.
That sounds like a great idea.
All right.
Thank you, Judge McBride and Judge Woolard. You are right. We are here at the end of our day. Thank you for carrying us through to the end. I really enjoyed all of those scenarios. That really brings to life some of those new ethical requirements and rules that we were discussing. So thank you both for that great presentation.